Hi, I'm Ward Lowe, and I'm here with Abby Lee, Associate Counsel at the Texas Association of Realtors. And we're here today to talk about fair housing. April is National Fair Housing Month, and so we thought it appropriate to review some fair housing rules that come from the Federal Fair Housing Act. And that act has 7 protected classes, which I'm sure most people know: race, religion, color, national origin, sex, familial status, and disability.
Got them all.
Okay, I did. Good. Okay. So what I thought we'd start with, Abby, is a few questions, kind of real-world scenarios about fair housing, and I know you have a new rule that you want to talk to us about the end.
Okay.
Okay. So the first question I have here is, true or false, realtors have an obligation to not discriminate that goes beyond fair housing laws?
So that's true. Under the NAR Code of Ethics, Article 10 talks about discrimination, and it actually adds an additional protected class that is sexual orientation. So above and beyond what the Federal Fair Housing Act may require, you are also prohibited from discriminating based on the protected class of sexual orientation.
Okay. That's not strictly a fair housing violation for the federal law, though. It's a code of ethics violation at this point.
Yeah, there is a HUD rule involving it, but under the Act, it's not included.
Okay. Let's try another one here. True or false, it's legal to only show your client properties in a predominantly Hispanic neighborhood if he says, I want to see properties in a Hispanic neighborhood.
So that would be false. You should inform your client at that point that you would be violating fair housing if your client asks you to do that. And the reason for that is...
Right, because your client requested it, is that...
Right. And the reason that you should say this, and I've got the language in front of me, is that you are not allowed to engage in any contact relating to the provision of housing which otherwise makes unavailable or denies dwellings to persons because of protected class. So kind of the logic behind it. But that could be included in that.
Okay, good. And the last question I'll ask you is, use some phrases that could appear in advertising that most likely would violate fair housing laws. And I'll give you a couple examples. Family room, is that okay to say in an ad?
That would be okay.
Okay. Kids welcome.
That would be okay.
That a property has a nursery.
Okay.
Located in the Smithson School District.
That's also okay.
Those are all okay.
Those are okay. Those are not providing a limitation or preference based on a protected class. Those are just the statements, but they're not indicating a particular preference or limitation either way.
Okay. Now let's jump to the last thing. You told me that yesterday you told me that there's a new HUD rule that was put into effect March 18th. Can you tell us a little bit about that?
Yeah, so that has to do with something called disparate impact. And essentially what that is disparate impact is the idea that if something has a discriminatory effect, even if the intent is not there to actually discriminate against someone based on a protected class, if it has the effect, it could still be held in violation of the Fair Housing Act.
Okay. Can you give us an example?
I do. So this is not one related to housing, but here's an example. So say that a city puts into play a requirement that any police officer for the city has to be a certain height, let's say 5'6", 5'7". Well, on its face, that's, there's no protected class based on height, obviously. Mm-hmm. You're not, on its face, intentionally discriminating against anyone, but because gender, sex, women may be shorter or typically shorter than the male gender, that could be something that could be held to have a discriminatory effect and therefore have a disparate impact on a protected class. So that's something that could be in violation of, well, in this case, employment laws, but could be held to be in violation of fair housing if it was related to a fair housing issue.
Okay. It sounds like a little bit of a legal gray area, that there might be a pretty big burden to prove that something had that, or?
It is. Actually, the act, or the rule itself, rather, did put into place a test for how you determine or how you establish someone has caused a discriminatory effect or something has led to a discriminatory effect. And it's a 3-step test. The first is that the plaintiff, in this case, would have to establish that some action did have a discriminatory effect. At that point, once that is met, that's proved, the burden would shift to the defendant to prove that the practice is necessary to achieve a substantial or legitimate goal.
So in this case, sorry to interrupt, but the plaintiff would be someone who feels they were discriminated against.
Exactly.
And the defendant may be a realtor in this case who didn't do something on purpose, but they may be on the wrong end
The
of
defendant
this.
would be.
Sorry, the defendant.
Yes,
right.
yes.
Okay.
And so once that is established, that the defendant met their burden, the plaintiff could come back, in this case, the person who's making the complaint, could come back and say, well, even if you did have a substantial or legitimate reason, there are other alternative ways to do this that would have a less discriminatory effect. So anyway, the rule clarifies kind of the burden or the test needed to establish the disparate impact.
Thank you so much for your expertise in this area.
Of course.